The morning started like any other. I was standing beside my old farmhouse, watching the sun rise over the fields, when 3 black SUVs stopped at the end of my driveway. 3 lawyers stepped out. Behind them came Karen, the president of our HOA. She walked toward me carrying a thick folder, wearing the confident expression of someone who believed the outcome had already been decided. "Good morning," she said. I looked at the lawyers, then back at her. "What do you want?" Karen smiled. "We're here about your farm." I leaned against the fence. "My farm." One of the lawyers opened his briefcase. "According to the HOA's interpretation of the community agreement, this property is subject to association restrictions." I almost laughed. "This isn't part of your neighborhood." Karen stepped forward. "It doesn't matter. Your property affects the community." I looked at the 3 lawyers. "Did any of you actually check the deed?" They exchanged glances. Karen immediately interrupted. "We've reviewed everything necessary." That was the first mistake, because they hadn't. For nearly 20 years, my family had owned this farm, the fields, the barn, the farmhouse, the private access road, everything. There was no HOA ownership, no HOA easement giving them control of my farm, and certainly no authority allowing them to take it. But Karen had already convinced herself that paperwork could make anything possible. She opened her folder. "We are giving you 30 days to comply." Comply with what? She handed me a notice. It demanded that I remove several farm structures, stop agricultural operations, and allow an inspection of my property. I looked at the paper. Then I looked at her. "You brought 3 lawyers to deliver this?" Karen smiled. "We want to make sure you understood how serious this is." I folded the notice. "I understand perfectly." One lawyer stepped forward. "You should consider resolving this before it becomes a legal matter." I smiled. "It already is." They didn't know what I meant. Karen certainly didn't. She turned toward her lawyers. "Let's go." But before they reached their vehicles, one of the lawyers received a phone call. He answered. His expression changed almost immediately. He looked at me, then at Karen. "There's a problem." Karen stopped. "What problem?" The lawyer lowered his phone. "The owner of this property has a current judicial appointment." Karen frowned. "What does that have to do with anything?" The lawyer hesitated. "Everything." I said nothing. I simply walked back toward the farmhouse. The next morning, Karen decided to escalate. She called an emergency HOA meeting. Her plan was simple. She wanted to convince the board that my farm was violating community standards and that legal action should begin immediately. She arrived with the same 3 lawyers. They were confident, until the courthouse doors opened. I walked into the courtroom, wearing a black judicial robe. Karen froze. The 3 lawyers froze. The room went silent. One of them whispered something to the others. Karen stared at me. "You're a judge." I walked to the bench. "Yes." Her face went pale. But there was something important she didn't understand. I wasn't there to hear her HOA case. I was appearing in my official judicial capacity for an unrelated proceeding, and I would never preside over a case involving my own property. Instead, the matter was immediately referred to another judge. That made everything even more interesting, because now the lawyers had to explain their claims to someone who had no connection to either side. The hearing began. The opposing attorney presented the HOA's documents. The judge reviewed them carefully, then asked one simple question. "Where's the deed showing the HOA owns this farm?" Silence. The attorney looked through his folder. "We don't have a deed showing ownership." "Then where's the easement?" Another pause. "We're still reviewing that." The judge looked over the documents again. "So you brought a legal action against a private property owner without confirming your authority over property?" Nobody answered. Karen sat completely still. Then the judge asked for the original property records. The county records were produced. The deed was clear. The farm belonged to me. The HOA had no ownership interest, no authority to seize it, and no legal basis for demanding that I surrender it. The judge dismissed the HOA's claims. But that wasn't the end. The HOA's own lawyers were now facing difficult questions about how the case had been prepared. Outside the courthouse, Karen approached me. For the first time, she wasn't angry. She looked embarrassed. I didn't know, she said. I looked at her. You didn't check. She lowered her eyes. You could have told me you were a judge. I shook my head. My job doesn't make my property rights stronger than anyone else's. She looked confused. Then why didn't you say anything? Because the law shouldn't depend on who is wearing the robe. That was the moment she finally understood. The robe wasn't what defeated her. The deed did. The property records did. The law did. And the facts did. For years, Karen had believed that confidence and expensive lawyers could intimidate anyone into surrendering. But my farm wasn't hers. And no number of lawyers could change that. I returned home that evening. The fields were quiet. The barn doors were open. The wind moved through the crops. Everything looked exactly as it had before the lawyers arrived. I stood on the porch and looked across the land my family had protected for generations. Then I smiled, because sometimes people think power comes from titles, money, or intimidation. But real power comes from knowing the truth and having the documents to prove it. Karen brought 3 lawyers to take my farm. They left with nothing, and the only robe that mattered that day was the one I wore when the law finally spoke for itself.